and welcome to, what is this now? This is week 8 of our government for the 2020 semester. We are going to focus today on the judicial branch of the government, federal judiciary, that is. And again, we'll go back to the very first week when we talked about U.S. government. It is one of the 3 branches of government: the executive, the legislative, the judicial. Legislative writes the laws, executive enforces the laws, and the judicial interprets the laws. Basically, the courts come in when there's a problem and resolve that problem, and because of that, were kind of seen by the founders, and I think we've done a good job of keeping this intact in modern society, where courts are kind of separate. I mean, yeah, they're all part of the same government, but we kind of consider them in a very special way, and I think we should. We'll get more to that. Third branch, again, the judiciary, the court system. This unit will look at the federal court system. And we're going to start off with a little bit of fun. We're going to take a look at a mock federal crime, look at how it is prosecuted, and look at all the things that happen in this case as part of a standard federal prosecution to kind of introduce you to all the parts that are at work. Now, again, this is not a state court system. States would look a little bit different, similar in some cases, but this is specifically for a federal crime. So let's get it started. At 4 a.m. November 10th, 6 federal agents broke into the apartment of a surprised Tom McHenry. He looked at them as he woke up. The agent told him he was under arrest and ordered him to get up, get dressed. Meantime, other agents began disassembling McHenry's computer setup. Going through his drawers, files, they found a package of specially made paper often used in counterfeiting. At the same time, 2 miles away, 6 other federal agents crashed into the home of Terry Kavanaugh. Government believed Kavanaugh was the leader of a counterfeiting operation. His computer revealed sophisticated software designed to copy U.S. currency. The agents arrested McHenry and Kavanaugh and charged them with counterfeiting. That's a violation of federal law. The agents took the 2 to the county jail, where the officers fingerprinted and photographed them. The 2 men were held there until they appeared before a federal magistrate to answer the charge. One important function of government is to enforce the law. Federal law enforcement procedures vary from state to state. But as we look at this fictional federal case, we will try to point to the elements which make a federal judicial system unique in and of itself. Most of what you've heard so far is from the executive branch of government, the agents and the magistrate. Well, the magistrate is courts. We'll get to that in a second. In this fictional story, the agents conducted a 6-month investigation. They saw some $20 bills had begun popping up in Illinois, and they knew McHenry and Kavanaugh were nearby, and they suspected, just through what they had been able to determine, that they were at the heart of this. Now, neither one of them had a criminal background before this, but based upon the information that they had obtained from other people, McHenry and Kavanaugh were behind these phony $20 bills. The Secret Service believed that they were part of an even larger operation based out of Chicago, which served several states. The federal authorities went before this federal magistrate, remember who we talked about earlier, to obtain a warrant to tap the men's telephone lines and listen in on their conversations. That's something they could not do without a federal warrant. At the state level, state police, state investigators, or Danville police investigators cannot tap your phone or your communications without getting a warrant from a magistrate. They also later obtained search warrants and arrest warrants after they collected enough evidence to be comfortable that McHenry and Kavanaugh were actively engaged in this. The search warrant has to list the very specific items that they're looking for, including, in this case, software, documents, and whatnot. That's when the legal procedure begins. Federal agents then arrested the men, told each man they had the right to remain silent. They had a right to have an attorney present at all times during questioning. If they could not afford one would be appointed for them. That's the good old Miranda decision, 1966. We'll talk about that a little bit more. The 2 men said nothing to the federal authorities. Lawyers came and advised the men to remain silent and only speak to them about anything having to do with the case. Men appeared before a federal magistrate 2 days later. Each of them pleaded not guilty to counterfeiting. A magistrate's an official who has very limited judicial authority. He's like somewhere between a clerk and a judge, not quite a judge, but does have some authority. The magistrate issues search warrants, the phone tap warrants. They set bonds. They hear the initial pleas from suspects. Magistrate usually handles more of these initial steps until a judge is brought in. Of course, a federal judge will preside over the actual trial. Magistrates set the bond that the men would have to pay. That's not a dollar amount you pay, but that's an amount that you put up with collateral, like the title to your house or something, that the government or a bail bond agency can seize your property if you don't show up for a later court date. They call it bonding. You're kind of bound to appear in court if your house is riding on it, basically. Every accused person has the right to post bond, except in capital cases. That is to say, any case where the death penalty is a possibility. Murder, of course, being the most conspicuous. Of course, a judge or magistrate can set the bond so magnificently high that 99.9% of the people could not possibly afford to reach it. This is called this is to prevent what they call a flight risk, someone who would fly away from justice. And if you're charged with a big enough crime, yeah, it's tempting to try to take that next train to China if you can, even if you have put up bond. And so if they think you're a flight risk, they're going to set the bond very, very high. In this case, this fictional case, that is, the magistrate, that is, decided to set bond at $500,000 each. Neither man could post this amount, so they stayed in jail until the trial. The magistrate then put the case over to what's called a federal grand jury. That's a specially called group of private citizens who will get together and hear the government's arguments that such and such person should be charged with, in this case, counterfeiting. Grand jury does not decide guilt or innocence. They can request evidence. They can ask for witness testimony to answer questions. A grand jury doesn't have to reach a unanimous decision because, again, they're not determining guilt or innocence. They're deciding whether or not the charge they should be indicted. That is a formal charge. You did this. That's an indictment. And the indictment is the document that sets out the formal charge against the defendants here. In this case, Kavanaugh and McHenry the grand jury voted that the government should try the cases, that they were indicted of U.S. counterfeiting charges. Then the U.S. officials decided to hold separate trials for the two of them. That's usually the way it goes. Sometimes they'll try defendants together when they're basically charged with the same thing, same operation. In this case, though, listen, they wanted one to testify against the other because they thought the other one was a little higher up the food chain. If they get him on their side, they can get him and then maybe get up a little higher in the food chain there. They offered what's called a plea bargain to McHenry. That's a deal where if you plead guilty to this lesser count, we'll go lighter on the sentencing, and you can give us information on this guy, and we can, make your stay at our prison much, much shorter. Federal judge, that's when the judge comes into the case. Magistrate's no longer involved. He held what's called pretrial hearings. That's the cases where the attorneys for the government and for the accused appear to ask that certain things be thrown out, ask for this. Sometimes they'll ask for what's called a change of venue. That is to say, they want the trial to be held in another locality. Often the fear is that because a case got so much publicity that it would be impossible to find a fair and impartial jury panel from that city or county. I've seen in several cases that's been granted before. A very high-profile, say, murder case, for instance, here in Danville. I've seen them get moved to Roanoke because, again, it was in all the papers. Everybody was talking about the murder, and it would be impossible to find someone inside the city who had not at least heard of this and, in some cases, formed their own opinion. In that case, the defense lawyers can ask for a change of venue. Also, as part of the pretrial rigmarole, the two sides, the attorneys, will exchange their witness lists, the evidence they obtained. All this is called pretrial discovery, where they share information, and they have to share information. One exception: if a prosecutor finds information as he goes over the case that would suggest the defendant is innocent, he is bound by law to turn that information over to the defense attorney. If the defense attorney runs into some information that would prove that his client is probably guilty, he is under no obligation to turn that over to the federal authorities. That's a little check and balance built in there. Again, we're trying to favor the accused here and give them every possible opportunity to present their case, they're not proving their innocence. We don't do that. We don't prove innocence. We prove beyond a reasonable doubt of guilt. You're assumed innocent. So all the dramatic and revelations during a trial, the surprise witness, that happens in the movies and on TV. It does not happen in real life very often at all. Some of this includes what's called depositions. That's sworn testimony that witnesses give before the trial. Again, they are under oath. They can't lie. And that's all part of this whole discovery process. We'll get to the trial now. Before this, McHenry agreed to the plea deal. He pleaded guilty and was going to testify against Kavanaugh. 8 months after he was arrested, Kavanaugh went on trial in federal district court on charges of counterfeiting. The first step, select a jury. You have to, in all federal trials, criminal trials, you have to have a jury. It cannot be tried by just a judge. State court, here's the difference. In state court, if you're arrested in the city of Danville for robbery, you go before a judge. You can request a trial by a jury or a trial in front of the judge. Federal court, it's going to be a trial of the jury. Depending upon where you are, 12 members and 2 alternates is usually the case. That's what has been sort of settled on over the years. The lawyers will get this pool together, and they will take out jurors that they think might rule against them for whatever reason. They're not supposed to do it based on race or religion or gender, but they do it all the time because really there's not much else you can get into. You can question them, voir dire the juror, to find out if they've had relatives who were cops or relatives who were criminals or whatever that might sway their opinion. During the trial, it depends upon the case. Trials can last a few hours. They can last a few weeks, several weeks in some cases, in the very complicated cases. It starts with opening statements. The government always gets to go first in these cases. Same at the state level. The prosecution goes first. After the testimony is presented, again, both sides have a chance to question all the witnesses and whatnot. You'll come to closing arguments. Then the judge will issue his charge to the jury. The judge's idea then is to tell the jury exactly what the crime is and what has to be met to prove guilt. That's it. Now, at this point, the jury can request more information. They can request transcripts of testimony. They can make a request to revisit a certain thing, but they have to get busy at that point. And to convict or to not convict requires a unanimous vote. Either way, you can't have a split vote to acquit or to convict. Now, to acquit, you can declare a hung jury if you're, hopelessly deadlocked and cannot get everyone to agree. That happens quite a bit, actually. In this case, McHenry's found guilty. In the federal court system, a judge has guidelines, very specific guidelines for what sentence applies to what crime. Has some discretion, go on the high end or the low end. In the federal court system, you cannot go over the high end. In the state court system here in Virginia, you can, but if you're a judge, you have to give a written reason why you decided to go above the recommendations. Federal court, you can't do that. In this case, Kavanaugh was given a 10-year federal prison sentence, just in case you want to know how this wraps up. Now, the appeals process happens after a conviction, obviously. What are you going to appeal unless you're convicted? The idea in a federal appeal is that the federal appeals court, in this case, does not retry the case. State court system, yeah, we have appeals courts where the case can be reconsidered from the beginning. The idea in a federal court system, the appeals process, the appeals court is going to consider a technical aspect of the case. Was the search warrant flawed? Did police legally and properly question the defendants? The appeals court looks to technicality. Was the trial handled properly? They're not looking at the evidence. They're looking at the process by which he was convicted. And if they find something technically wrong, a technicality, if you will, they will send the case back to lower court. Say, for instance, in this case, they decided that the police illegally questioned Kavanaugh before telling him he could have an attorney. All of that testimony that Kavanaugh gave to them under that situation is null and void. In that case, the appeals court says, no, you got to retry this case without this evidence. Sometimes the prosecution will decide, well, if we don't have that evidence, we're not going to get a conviction. And so they scrap the case and Kavanaugh goes free. Again, on a technicality, but these things are in there for all our protection. The losing side in a Circuit Court of Appeals case can go to the U.S. Supreme Court. And again, most of what the Supreme Court is looking at here is over the way the trial was conducted and the evidence collected, and whether the law that's being applied here is constitutional in the first place. That's one thing the Supreme Court considers. Yes, he was convicted, all this jazzmatazz, the police acted properly, but the law under which he was convicted, is that constitutional? That's a question the Supreme Court will consider. Now, persons and groups, of course, the idea of having a legal system is certainly not unique to the United States. Throughout history, people have come up with different ways to resolve conflicts. One of the first issues Moses had to face after leaving Egypt and beginning wandering in the wilderness was a way to settle disputes among tribes of Israelis. They came up with the system of judges that really ruled Israel for several centuries after that. The American legal system, adopted largely from Britain's legal system, originated King Henry II of the 1100s, 12th century. The practice of appealing goes back to Roman times. If you were a citizen of Rome, as Paul was in the New Testament, you could be convicted anywhere in the Roman Empire, but you had the right to appeal directly to Caesar himself. And Paul took that right at one point. So yeah, the idea of appealing a court's decision is nothing new. When the United States of America was formed, you'll remember we started with the Articles of Confederation. One of the things, one of the shortcomings we quickly discovered with the Articles was that while they set up a system, the state court systems, all 13 of the colonies would have their own state court systems, it did not create a national court system. So if you were in New Hampshire and you exhausted your appeal in New Hampshire over a constitutional question, where could you go after that? Well, there was nowhere you could go. It became apparent quickly that we needed a national legal system to address issues that have to do ultimately with the application of federal law. Article 3 of the Constitution provides for the national legal system. Judicial power is vested, technically, according to the Constitution, in the U.S. Supreme Court and in other courts that Congress might establish. The Supreme Court's the only court set up by the Constitution. All the rest of the federal courts have been created by Congress. We have, and I'll show you here this little slide. This gives you more or less an idea of what we're talking about when we discuss the federal court system. It's not terribly complicated, simply because, I mean, there's only a handful of these courts in use. It's not a very, this isn't like that, oh God, that thing I showed you last week with the 500 blocks and letters. No, it's nothing like that. But this right here does give you a kind of an overview. This kind of shows what we're looking at here. This would suggest like 4 or 5 levels. That's not really the case. The meat and bones of this are right here, right in the middle, where it says U.S. District Courts. There are 94 districts. And if we're talking about going to a federal court, this is probably what we're talking about at first, the district court level. There are 94 of them throughout the U.S. Under them, you see the bankruptcy court. That's considered different. They, of course, handle bankruptcy cases. And down here in the green rows, as we call them here, you have what's called federal courts, special courts, which are sort of outside the judicial branch, but whose cases can be appealed ultimately to federal courts at some point. So again, in that you kind of see what we're looking at here in terms of the federal hierarchy. It's not that common. Most of what we're concerned with is district court, appeals court, Supreme Court. The federal cases start off at the U.S. District Court, again, one of these 94 districts. Danville is in the Western District of Virginia. I'll show you that map here. You get a little idea of where we are in terms of what the geography looks like. Again, it's divided into divisions. That's where courthouses are. Down here in the blue, Danville is has the courthouse in that little division. And each division will have a usually a sitting judge. There's judges that work cases in several of the divisions. But everything to the left of this scraggly red line that goes here is considered the Western District of Virginia. And again, it is one of 94 districts, courts in the United States. The president nominates all the judges in all the district courts, 94 of them. Some of the district courts have 8 judges, some have 10, some have 12, depending upon the population. So you can see how that would be very busy. Again, checks and balances alert. The president nominates these judges for their post, and who confirms them? The Senate. And we have had an awful lot of federal judges that have been appointed in the past year because we've had a Republican president and a Republican-led Senate. They can agree on an awful lot of stuff and get a lot done when it comes to appointing judges. Conversely, if they are opposed to each other, you get a lot of vacancies then because they cannot agree. Judges, again, are supposed to apply the law even-handedly. Republicans, though, Republican presidents are going to choose judges that mostly tend to appear to agree with the president, and a Democratic president is going to do the same darn thing. That's the way it is. Judges are supposed to be impartial. They don't run with the political parties. You'll be surprised to know, and it still boggles my mind, that at the state level, we have many, many states where judges are elected. Virginia's not one of them, thank goodness. They're appointed by members of the state legislature, the General Assembly, and so forth. But in many states, North Carolina is a state that elects judges. So judges have to run for their seat. They have to campaign just like any other politician. They have to raise money, put up signs, make stump speeches somewhere. What are your thoughts about that? I want that to be a discussion question on Monday. Is it a good idea to have judges elected? Sometimes a judge will make a very unpopular ruling, and if they've got a lifetime appointment, then you're not going to get rid of them unless they do some kind of obvious malfeasance. But do you want a judge that's looking over your case to be more interested in their next election than getting your case right? What if it might benefit him politically to get your case wrong? That's no fun. Be ready to discuss that Monday. That'll be a good discussion. Section 2 of the Article 3 of the Constitution talks about jurisdiction questions and the right to a jury trial. Federal cases obviously hear cases involving federal law and equity. If it's a crime that involves more than one state, it's considered a federal crime. Criminal law basically is crimes against people. Civil law is a dispute between two individuals, two entities, or whatever, where there's no criminal victim involved. In a criminal case, the government always prosecutes a case surrounding criminal law. Again, we are innocent until proven guilty. That is huge. You will not believe the difference it makes. There have been some societies in the past where it was just the opposite. If they charged you with something, they assumed you were guilty. You had to prove your innocence. Think about how the issue is, how hard is it to prove a negative? How hard is it to prove something did not happen as opposed to did happen? If you think about that, that is almost impossible. It is almost impossible in most cases. Thank God we have adopted the principle of innocent until proven guilty. And that raises the threshold to a reasonable doubt. Can you prove he is guilty beyond a reasonable doubt? An unreasonable doubt is, well, aliens could have landed and put the gun in his hand. Yeah, that's not a reasonable doubt. It's got to be reasonable. We mentioned civil law is a dispute, usually a property dispute between two entities. Beyond a reasonable doubt doesn't apply in a civil case. You have to prove within reason. The court finds you guilty of, taking this or, not agreeing to this. Doesn't have to be a reasonable doubt threshold there. A matter of dispute might not involve breaking a specific law, but it involves someone believing that the other party has not treated them fairly, and he wants to take the alleged wrongdoer to court, a discrimination case perhaps. Section 2 of the Article 3 of the Constitution lists the kind of cases that federal courts hear. Cases involving ambassadors, ministers, and consuls. The framers didn't want representatives of foreign governments to be harassed by state courts. Also, cases involving maritime issues. They're on the water. Again, if you're off the coast of Carolina, how do you prove that's not off the coast of Virginia? Yeah, jurisdiction is federal then. Cases where the U.S. government is a party will always be a case for federal courts. Cases involving a dispute between one or more states. Now, the 11th Amendment to the Constitution set up this provision that a citizen of one state cannot sue another state or a foreign country in federal court. The amendment, the result of a case in Georgia where a citizen of South Carolina sued the state of Georgia. Georgia claimed to be a sovereign government, not subject to federal courts, and thus sent no representatives before the court. It got messy. So basically, the 11th Amendment clears that up. It also limits federal court jurisdiction over the states in many cases. The Supreme Court has original jurisdiction in cases involving, like we mentioned, anyone from overseas in terms of an ambassadorial standpoint. What we mean by that is the Supreme Court and not a lower federal court will hear these cases. In all other federal cases, the Supreme Court has what's called appellate jurisdiction. That is to say, the case does not originate in the Supreme Court. It is appealed to the Supreme Court. Congress can make laws regulating and making exceptions to that, but they cannot extend the Supreme Court's area of original jurisdiction unless they change the Constitution. Again, we mentioned that juries must hear all federal trials. The Marbury versus Madison decision. This is a biggie, 1803. The Judiciary Act from a couple of years earlier had given the Supreme Court an additional original jurisdiction in a matter. The court said Congress could not do that in Marbury versus Madison. Basically, Marbury versus Madison gave courts the power to determine if a law is constitutional. It was really nowhere that everyone agreed on that a constitutional law could be declared constitutional or unconstitutional. Who does it? In this case, Marbury versus Madison makes it clear. That is up to a court. And in this case, only the U.S. Supreme Court. A lower court can rule something's unconstitutional, but that doesn't always have to stand. The federal court, the Supreme Court, that is, has the final say on whether it is or is not constitutional. The only crime mentioned specifically in the Constitution is treason. That's the only one. That's the act of making war directly or indirectly against the United States or her allies, or by giving the United States enemies aid and comfort. Does not consist of thinking wrong things. It has to be an act. We have to guarantee freedom of speech and freedom of thought. Also, another legal threshold there, you have to be convicted by 2 witnesses in cases of treason. That prevents, for the obvious reason, somebody who hates you saying, yeah, I saw him do this, lock him up. Now, you got to do that. And that's, again, federal. The burden of proof is on the government, not on me. The burden of proof is on the government to prove beyond a reasonable doubt that I am guilty. About 30 treason trials have taken place in the U.S. over the years. The most famous, Vice President Aaron Burr, the one who shot and killed Alexander Hamilton, he was suspected of trying to push for the formation of a new country in the Louisiana territory that we had just purchased. Virginia State Court found him guilty, but the U.S. Supreme Court found him not guilty. In Virginia, State Court found John Brown guilty of treason for his raid on Harper's Ferry, which was a big cause of the Civil War back in 1859. The exercise of justice. The federal district courts, we've talked about them. The district courts, the courts of appeal, and all those specialty courts. Remember that little thing with all the green? Yeah, those are the specialty courts. The lowest level and the most obvious level are the district courts. We mentioned there are 94 of these, 678 federal judges to hear cases at this level. Again, the president nominates each judge. The Senate Judiciary Committee considers the nominee. The full Senate votes to confirm. That, in years past, has been a fairly routine thing. Now it's not so routine. As the court has gained a lot more power, and we'll talk about this as we go on, some of the really consequential decisions that have been made in court, not in Congress, not in the Oval Office of the White House, but in court, that has put a lot of attention, obviously, on the judges. And if we have situations of a divided government, that is to say, a president from one party, a Senate controlled by another party, the appointment of these federal judges is going to be at loggerheads. When Democrat Obama was president, Republican minorities at the time in the Senate used the filibuster we talked about to prevent a lot of judicial nominees. Democratic Senate Majority Leader at the time, Harry Reid, ended the federal filibuster for judicial nominees, except for the Supreme Court. That way, instead of needing 40 votes or needing 50 votes, gosh, let me get it right here, needing 60 votes to proceed, they could do it with only 50 votes. And because it was a very slender majority, that made the Republicans powerless. Well, fast forward a couple of years, and 2016, Antonin Scalia passes away. President Obama, 8 months to go in his term, he nominates Merrick Garland for the Supreme Court. Now, the Senate, now controlled by Republicans, says, well, we can give advice and consent, and our advice is, well, we'll tell you tomorrow. Now we'll tell you the next day. They basically sat on it and waited for the next election. Of course, Donald Trump, a Republican, won that election, and the Trump nominated Neil Gorsuch, and the Senate, controlled by Republicans now, gleefully adopted Gorsuch. Before then, though, they did what? They ended the filibuster, because that filibuster ending by Reid applied only to non-Supreme Court judges. This is a Supreme Court case, so with that precedent having been set, new Senate Majority Leader Mitch McConnell said, okay, we'll do away with the filibuster for Supreme Court nominees. Now, we don't need 60. We need only 50 votes. And that's about what they got exactly. Again, as the courts take a mightier role in our politics and our lives, we're going to pay a lot more attention to not only the Supreme Court judges, but the federal court judges that we nominate. I'm just going to mention in passing just some of the federal specialty courts, just FYI. We have the Court of International Trade, which governs issues of international trade, federal bankruptcy courts. All federal bankruptcy hearings go through. The Court of Federal Claims was set up about 40 years ago to hear charges that people bring specifically against the federal government. Usually, if you're a contractor working for the federal government and you think there's been a breach of contract, that's where you would go. The U.S. Tax Court hears tax cases, as you would expect. And the Tax Court Office in Washington will field those. Those are the specialty courts. Above the district courts, go back to the map here, you have the Federal Circuit Courts of Appeal. When a federal district court reaches a verdict, the losing party can appeal here. An appellant has to make his appeal for review on one of two grounds. These two things, one of these two things has to be true before a circuit appeals court will bring it up. The person can claim that the procedure of the district court was faulty. Perhaps the judge admitted false evidence into the trial. Judge might have been lax in his duties. Anyway, if there was a procedural error, the circuit court, appeals court, can take it up. Or the person can claim that the law of which he was convicted was faulty. That is to say, unconstitutional. In other words, district court, the defendant's on trial. In the appeals court, the district court trial, or the law itself, is on trial. There have been a few type of cases that they can appeal directly to the Supreme Court, but for 99.9% of them, if you appeal the district court, it's got to go to an appeals court, and it has to be either a procedural grounds or constitutional grounds. We have 11 circuit courts. The D.C. Court of Appeals was carved out to hear appeals in cases directly involving the federal government. A 13th appeals court was set up in 1982 called the Court of Appeals for the Federal Circuit. They have to do mainly with appeal cases and patents and things like that, international trade, claims against the foreign government, things like that. We also have two other appeals courts that don't have geographic jurisdiction. The Court of Appeals for the Armed Forces, which takes appeals of military court verdicts, and the Court of Appeals for Veterans Claims. Not going to require you to know all that, but just know that in addition to the district courts and the appeals courts, there are some other courts that are part of the system but don't hear nearly as many cases as the big boys. There's the U.S. Emergency Court of Appeals, 1942, that had to deal with wartime rationing. That was disbanded after there was no more war. At this level of the judiciary, we mentioned 678 federal district judges. There are 179 appeals court judges. So you add all that up, and that's nearly 1,000 judges working the federal judiciary. Appeals courts, again, they don't have juries. They have three-judge panels that will rule, and if you don't like the three-judge panel's ruling, you can appeal it to the full court. That happens all the time. Here in Danville, we are in the 4th U.S. Circuit Court of Appeals, which covers West Virginia, North Carolina, South Carolina, and Virginia. It is based out of Richmond, just for your information. The Supreme Court, the granddaddy of them all, arguably the most powerful small group of people on the planet. Neither Congress nor the president can reverse a decision they make. The only way you can really reverse it is to change the Constitution. A Supreme Court ruling can wipe laws off the books. It can undo a president's foreign policy. It can undo a treaty. And they are very much the final say in a lot of things. Checks and balance time. No one can force a Supreme Court justice to leave their position unless the House impeaches and the Senate convicts. That has never happened. But that is a potential check. If you have a Supreme Court justice who is clearly going insane, difference of opinion doesn't count, then that process is there, but again, it's never happened. Supreme Court began in 1789 with 6 members. It grew to 10 by 1863. 3 years later, Congress and then President Andrew Johnson were at loggerheads over a bunch of things. Johnson was a very, very bad president, and Congress did not want to give him anything. The next 3 vacancies that he proposed to the Supreme Court were left unfilled simply because they didn't want to give him anything. In 1869, after Johnson was gone, the Congress passed a law setting the membership of the court at 9. You're hearing a lot today about possibly expanding that membership. That can be done without a constitutional amendment. That is an act of Congress. Congress can approve that without changing the Constitution. 112 different people have served on the Supreme Court, including the latest, who was put in exactly 6 days ago, Amy Coney Barrett, the 113th member of the Supreme Court. Supreme Court nominations have not always been the life or death blood sport that they've become in the recent years. Matter of fact, there have been some confirmations that have lasted exactly a week or so. Really weird. But now, again, as we mentioned earlier, because the court is holding a lot more power in their hands, there's a lot more at stake in getting the right Supreme Court justice on the bench. The Senate over the years has rejected 12 judicial nominees. 4 of the rejections have come in the last 2 generations. Jimmy Carter, the only president to have served at least 1 term who never got to make an appointment to the Supreme Court. Nominations, again, have become a very, very big deal. Because the Supreme Court has had a whole lot of 5-4 decisions, we'll get into that in a second when we talk about some big cases, you can see how crucial it is to have someone on the Supreme Court, as many on the court as possible, who agree with you politically. Now, again, the judges don't wear red robes for Republican, blue robes for Democrat. They wear black robes. They're supposed to be neutral. In a perfect world, they are absolutely 100% non-political, non-partisan. We don't live in a 100% perfect world. Not even close. So yes, judges are human beings. They're going to tend to lean to the left, lean to the right. There are some that are very close to being center, and there are those who will surprise you with their rulings. Antonin Scalia, the judge that I respect more than any other, several times came down in a decision that benefited, quite frankly, the left. When asked about it, he said, hey, if you're a judge, if you are an originalist, that is to say, you read the Constitution and interpret the words as their original intent would be, sometimes you're going to come down with a ruling that you don't like. But if you like every ruling you make, you're not a good judge. Amen to that. Sometimes the law, the truth, the Constitution is going to land you in a spot that you would not have picked yourself. Without some process for determining a law is in the bounds of a constitution, the Constitution would be meaningless. So the Supreme Court's ultimate responsibility is the judicial interpretation of that document we all love so. And Marbury versus Madison gave them the authority to do that. The Supreme Court will receive about 7,000 requests to take up a case. They accept about 100. So if you file to the U.S. Supreme Court and they agree to hear your case, you're lucky. That's a very, very big deal. The procedures and the traditions of the Supreme Court and the way they conduct their business, there's a couple of antiquated things, but they will give each other a handshake when they meet in open session. All 9 will shake the hand of all of the 9 as a way to show we're all on the same team here, even if we disagree mightily about a certain case. The court's traditions add an interesting mix to the whole state separation of church and state. Part of the public session of the court starts with "God Save the United States." So anyway, just a weird thing. The guiding principles of the Supreme Court are many. The biggest one is stare decisis, which is Latin for "let the decision stand." In other words, the precedent of previous Supreme Court decisions plays a major, major role in the Supreme Court's deliberations. The Supreme Court doesn't always get it right. For 60 years, the Supreme Court of the United States told us that segregation was okay legally. The Plessy versus Ferguson ruling in 1894 said that if a locality offered a drinking fountain for whites and one for blacks, with criminal charges for those who violate that, they said that was okay. They said that was separate but equal. They got that wrong. They got that spectacularly wrong. And it took 60 years for Congress, or for the Supreme Court, I should say, to reverse themselves. And again, like so much of everything else involved with state-sponsored segregation, it's a scar. And I am so very glad that we're putting that in the rearview mirror, and we are making it, we are creating generations of people who look at that and go, how in the heck could you have allowed that to happen? May we always think like that about such things. Another principle the Supreme Court follows is sort of a reluctance to get involved in what's purely a political or a legislative issue. If there's a case that someone asked the Supreme Court to take up that is just bare-bone politics, again, whether you agree with it left or right, the Supreme Court is probably not going to take it up. Third guiding principle of the court is the protection of personal liberty and individual conscience. The decision to outlaw school prayer, unpopular though it may be with some, was made on the basis of personal liberty. The court infers an individual's right to privacy from the Constitution. They've used that to uphold abortion as well. So, yes, you might not agree with it all the time in terms of individuality, but the court generally has favored the individual, that individual right to be left alone, that individual right to not be forced to do anything. But again, they haven't always followed that principle. The United States is a nation of laws. The founders established our government and the Constitution. On the national and state governments act on the basis of laws passed by legislatures elected by we the people. The person or body that's able to say what the law is, as John Marshall put it, obviously has a powerful role in government. The Supreme Court fills that role in our society. And one of the things, again, we kind of treat courts separately. We view them separately. Politicians, presidents, they get out, they hem and haw, the Supreme Court's not supposed to be above that. A judge, you don't hear a judge yammering in the public square about any hot-button issue. Judges generally keep themselves separate. They walk circumspectly, as Christians are supposed to do, oddly enough. Let's look at this final chapter, looks at the question or the statement, how 5 people can change your life. 5 is a majority on the U.S. Supreme Court. And a lot of very crucial, fundamental decisions into how our government works and how we lead our lives have been decided by 5 people in black robes. The American legal system, like we said, has sometimes allowed injustices to take place. And you hope that the court would be the last place where injustice would occur. Unfortunately, it's made up of people. Again, we all know the checks and balances. Congress enacts the laws as in a constitutional manner. The executive branch formulates regulations that sometimes have the power of law, and Congress has given this authority to the executive departments. President appoints members of the Supreme Court, Senate ratifies. We're aware of all that. The actions of the Supreme Court are just one way that the federal government plays a ever-widening role in our lives. Since a Supreme Court decision needs only a simple majority of justices, it is possible for 5 people to change lives for over 320 million Americans. We'll have a discussion in class about how that makes you feel, that fundamental part of your well-being is in the hands of 5 people. Let's look at some key Supreme Court cases. I think we're looking at 5 or 6 of them here, and we'll close out here. The Helvering versus Davis decision in 1937. Supreme Court struck down a lot of Great Depression proposals from Franklin Delano Roosevelt, the president, because they went beyond the powers that the Constitution delegated to the federal government. The 10th Amendment! Yes, I love when the 10th Amendment wins. And they basically said, no, you can't do that. Roosevelt responded with a threat to add 40 justices to the court, appoint people he liked, put them on the court, and then the court will reach a different decision. That's called court packing in. You've probably heard an awful lot about that lately. The only way you can pack a court is by adding members. There are people who disparagingly say Donald Trump packed the courts. You don't pack the courts by filling vacancies. That's impossible. That's something else. That's legal. That's what you do. You got vacancies, you fill them. Packing the court has a very specific meaning. It means adding judges to a court and then filling them with whomever you like. He never went through it. Thank God Congress basically said, no, we're not gonna back you up on this. And he never did. But we're starting to see rumblings of how powerful this Supreme Court is. Now, George Davis was a shareholder in the Edison Electric Company. He went to court to try to prevent the company from taking Social Security deductions out of his paycheck. He claimed that the law was unconstitutional. In its 5-2 decision, the court found that Social Security law was constitutional under the General Welfare Clause of the preamble of the Constitution. Remember when I said that you can make just about anything constitutional if you interpret general welfare too loosely? Well, I don't know if they interpreted it loosely here, but this has cleared the way for the government, for Congress, to take steps into a lot of things that they would not have ordinarily. The Congress in the Supreme Court in this case ruled that this was Social Security was something that people needed, and the state governments were not big enough to provide it. Only the federal government could, so therefore, under general welfare, they could do it. The result has been an ever-expanding number of areas where Congress has gotten involved since then. On the good side, Brown versus Board of Education, Topeka, Kansas, 1954. Like we said, until the 50s, the Supreme Court either did not get involved with laws around segregation, or they supported them. Again, 1896, Plessy versus Ferguson, separate but equal. Other than that, for the next, like I said, 50 years, the Supreme Court didn't really take up too many of these cases, wanting to leave that up to the courts, to the states, we should say. American society began to change. In the World War II era, a lot of people began to see the absolute freaking hypocrisy of saying someone is an inferior person when you are willing to put a gun in his hand and have that person die for you. Do you think he's inferior to you? A lot of people with World War II and with many other things began to see just how obnoxious, how poisonous that line of thinking was, and began thinking, you know what? Maybe it's not right that he has to sit in the back of the bus and I don't, that he has to drink from that water fountain and I don't. Maybe that's not a good thing. Finally, society caught up with decency, and the court finally caught up with it as well. 1954, they ruled that the forced integration of schools in Topeka, Kansas was constitutional. They ruled that separate is inherently unequal, and therefore it was a violation of the Equal Protection under the Law clause of the Constitution. Separate is inherently unequal, and groups in states that where segregation had flourished for decades fought it. And even then, the cases involving this went on into the 1970s. But the Brown decision was a key turning point in the movement towards equality within a decade. We had a federal Civil Rights Act. We had two of them that gave legal teeth to efforts to stop discrimination based on race. The Miranda versus Arizona case, 1966. Fellow was arrested without a, let me give you a little background. It was 1914 when the Supreme Court ruled that you could not, the police could not go into your home without a search warrant. It was 1963 when they ruled that an accused person has the right of legal representation, even if they could not afford it. In 1964, Phoenix police arrested Ernesto Miranda and questioned him about a crime for 2 hours without his attorney present. Police did not tell him of his right to have an attorney present. Miranda gave a confession. He was convicted, but later that conviction was thrown out because the police did not tell him he could have a lawyer. The Fifth Amendment's protection against self-incrimination applies in all settings. Therefore, when someone gets read their Miranda rights, it's from the Miranda decision. People have to tell them they have a right to remain silent, that any statement they make could be used against them in court, that he has the right to have an attorney present. If you cannot afford one, one will be appointed for you. This spelled out the specific wording that police or any arresting agency has to inform them of. The Miranda ruling and others dealing with the rights of accused person protect accused persons from the power of the state. It can be very frustrating, I'm sure, for police officers, the vast majority of whom are just fine people who are trying to do the right thing. I know it's very frustrating to give so many rights to the accused, but at that point they are the accused. They're not the guilty. They're the accused. There's an old saying, I would rather for 10 guilty ones to go free than for one innocent one to be locked up. We have our laws are bent towards the presumption of innocence. I'm going to ask you about that statement. I'd rather 10 guilty ones go free than one innocent one be arrested. I'll ask you about that in class Monday. The next three cases, the last three we'll point out, were actually all done within the past decade. Citizens United case in 2010 determined that even though we were trying to get a handle on the money that was involved in political campaigns, that you could not tell a corporation or a union or any other large group that they cannot contribute, that they as a corporation have a corporate First Amendment right. That has been very, very big, and we're still grappling with that decision in the way we run our campaigns. 2012 and 2014, two cases of the Affordable Care Act. And the Sebelius case, the Supreme Court, 5-4, get used to that number, 5-4, ruled that the so-called individual mandate, which required that a person purchase health insurance or face a penalty, pay a penalty, they ruled that was constitutional under the Commerce Clause, that the individual mandate was a tax, not anything else, even though the ACA was sold, a mandate that is, was sold to us as not a tax. Supreme Court ruled it was a tax, therefore okay. Here's the problem. The ACA bill was originated in the Senate. This is a tax bill. Where are tax bills supposed to originate? Remember from week 2? They're supposed to originate in the House. It sickens me still that no one cares about this, that we're still just bebopping along like nothing ever happened, like the Constitution has not been violated. If you want to go back and fix it, then fix it, but don't leave it like this. Don't leave me with a revenue bill that originated in the Senate, because they're supposed to originate in the House. If I'm getting a little hot about this, it's because this is very recent, and we collectively as people have not raised our hand up enough and said, hey, you can't do that. And that's distressing. Also, the fact that any judge can look at the Commerce Clause of the Constitution and infer in that the right to make me purchase something, regardless of whether I want to purchase, that is repugnant to me. I don't care about the healthcare, the ACA, all that. That's an entirely different set of debates. This is over whether the government can force me to purchase an item that I don't want. I get a little hyped about that. Also, 2014, 2 years later, in the Burwell versus Hobby Lobby case, the court did strike down another provision of the Affordable Care Act that forced insurers, forced employers to provide insurance that included contraceptive. The people who owned Hobby Lobby had religious objections to that, and because they had a closely held belief in that, the Supreme Court, 5-4, ruled that Hobby Lobby did not, or no one else had to offer health insurance plans that went against their religious beliefs. Just 5 years ago, the Obergefell versus Hodges, a 5-4 decision again on same-sex marriage. Basically, the decision said that the Constitution does not specifically addressing marriage per se, it does allow for equal protection under the law. And that if a state recognizes a marriage between opposite-sex couples, they have to recognize it between same-sex couples. The arguments against that was that the federal government had no role in defining what marriage is anyway, and they're probably right, but that was not the question at Obergefell. It's whether a state can recognize one kind of marriage and not another. They said they couldn't, and of course, from that point on, gay marriage has been, legal in the United States. We're almost at an hour, so I'm going to wrap this up very quickly here. This was not quite as boring as last week because the courts play a substantial role in our day-to-day lives. This is not ancient history. This is contemporary. This is happening now. The Supreme Court, the shining jewel of the American judicial system, is in a spotlight right now and is undergoing quite a bit of change right before our very eyes. This isn't history. This is now. Anyway, we'll talk a little bit more about that next week, and try not to keep it out. Try not to go to an hour. Folks, y'all have a great weekend.